question. Now, the final area is listening. Listening is one of the hardest things at trial. When you get to trial as an attorney, you should be so familiar with the facts that they're rote to you. It's as if they're memorized, but you can't let that jury know they're memorized. And sometimes when you're very familiar with something, you tend to not listen to everything that's said. You know what the answer is going to be when you ask that question. But it's imperative in trial that you listen to everything the witness says to you. Sometimes witnesses will give you answers that weren't what you talked about when you prepared the witness. Sometimes witnesses will add information and you'll have to steer the witness back. Sometimes the witness may just forget what it was they were supposed to say. In those cases, you should be ready to refresh the witness's recollection, to take a document, perhaps it is a picture of what happened, and ask the witness if looking at the picture would refresh his or her memory as to what color the car was. And that's why it's so important, as I indicated earlier, that you are familiar not just with the testimony of the witnesses, but as to the exhibits that show things, so that you can pull out those documents, pull out those pictures, and use them if you need to in order to refresh a witness's recollection. Now, if you're talking to an expert witness, the speaking and the listening are going to be two different areas. In preparing or starting the speech, starting the direct examination of an expert, you're not going to need to make that witness feel as comfortable. Most expert witnesses have testified in court before, although every expert, like all of us, has their first time testifying. With an expert witness, you're going to start off, again, with basic questions. You want the jury to trust this person because of their experience. So with an expert, you're going to start off with what their qualifications are, what kinds of things that they've done that make them qualified to give opinion testimony. You're probably going to ask the expert if he or she has been paid. Again, that's one of those bad facts that the other side may come out to make it look like you're paying for the testimony. And you can set up the expert witness to make that sound perfectly normal, because this is that person's job. And all of us expect to be paid for doing our job. And you can ask those questions of an expert as you set up the facts. And then you'll go into the opinion testimony. And when you ask those questions, you're going to be acting and asking your witness to act like a teacher. You're educating the jury, because an expert is only going to be testifying if he or she has information that an ordinary juror wouldn't have. So your questions in that situation are going to be more like you were engaging in a question and answer discussion, so that you can inform and teach the jury about the particular facts. Some of the best witnesses, in terms of expert witnesses I've had, are experts who are able to just pull out an exhibit or say, can you show me that diagram and let me use that to explain my answers. In today's world, whether you have a fact witness or an expert witness, people expect to see visuals. So use your exhibits, whether it's putting something up on an AV board, using a PowerPoint presentation, or sometimes just using a flip chart and writing answers to questions. And I do that a lot with economists, where I'll just write numbers down. That engages the jury. It gives them the ability to use their senses, not just the sense of listening, but also the sense of seeing, because they're watching and absorbing the information that you present that way. And when you are writing down things as an attorney, that's also going to force you to listen to what the jury is saying. So whether you're writing down answers to questions or numbers that an expert might be giving you, or making X's on a diagram of the scene from a fact witness, those are ways, those are techniques that you can listen to best be able to tell your case or explain your case to the jury. One of the most important things is getting a witness back on track. And if you're listening to a witness, carefully you'll be able to get that witness back on track if the witness roams away, and that's again where you're going to jump in and strategically interrupt. So in preparing your witness and preparing yourself for direct examination, you want to make sure that first you prepare both yourself and the witness by being familiar with all of the facts, the relevant facts, and the possible objections. When you speak, you want to give thought to how you're going to ask questions, where you're going to stand when you ask questions, what the tone of your voice is, and what the purpose is for calling that particular witness. And then as the witness is testifying, listen to what that witness says and make sure that you follow the story and get the story back on track if you need to, and listen to make sure that the witness has really answered the questions that give those jurors the 2 or 3 key points they'll need when they go back in the jury room to evaluate the evidence with which they've been presented. Thank you very much and good luck.